And you are the legal father because you're married to Serenity's mom, but are you wondering whether you're the biological father?
Wait a second. This case is already taking a dramatic turn. The legal father is saying he already took a home DNA test and believes he's not the biological father. But in family court, biology isn't always a deciding factor. Sometimes the law cares more about legal responsibility than DNA. Keep that in mind. It becomes very important later.
I did a home DNA test, so I know I'm not.
Okay.
But
after appearances.
Lee Heiss, lawyer guardian ad litem.
Nastasia Thomas, counsel for the department. Ms. Madrid.
Francesca Madrid, foster care worker from Fostering Solutions.
Tamiris Hennigan on behalf of Darnell Edwards.
Good afternoon, Ariel Berger here on behalf of Father Trevon Rowe. Okay, Mr. Rowe, do we have you with us?
Yes, ma'am.
Okay, great.
Michael McFarland representing Alexia Rowe. Ms. Rowe, please introduce yourself.
I'm Alexia Rowe.
Thank you.
Thank you. All right. As it relates to your claim, Ms. Hennigan, would you like to update the record?
Yes, Your Honor, thank you. I was just able to contact my client. He was at work today. He answered the phone when I called PFC and he indicated that he is leaving right then. So I'm expecting him here within the next 5 minutes.
Thank you. Were you able to meet with him as ordered at the last hearing?
Your Honor, I was not able to meet with him. He scheduled an appointment to meet with me on October 27th so I could guide him through completing the final form that he needed. And he did not come to his appointment with me on the 27th. And I had not heard from him since until I just spoke with him.
Thank you. I would note the order issued October 24th does indicate the adjournment was to allow Darnell Edwards to complete custody paperwork and file the same, and that must be done by 11/8/23 or show cause will be held. So we'll re-advise with that when he gets here and go from there. Any other comments about the sidebar while we're at it, Ms. Hennigan?
No, Your Honor.
Mr. McFarland?
No, Your Honor.
Ms. Berger?
Nothing to add, Judge. Thank you.
Ms. Thomas?
Nothing to add. Thank you.
Ms. Heiss?
No, thank you.
All right, here we are over at Ms. Heiss. Why don't we have your report, please?
Thank you, Your Honor. I visited with the children face to face. The older two were in the care of their father, where they've been stabilized. Some nice things to report is that the little boy, Jay, well, he doesn't have the right last name yet. Anyway, I hope to get to that because we've got one child stuck with the wrong name. Anyway, last name. He participated in honors choir, and boy, did he do a great job. So it's really good to see that the family has made a commitment to getting him to those practices, that his grades were good enough, his behavior was good enough to do that. So the children's needs seem to be met at that placement. Custody. If the dad were to establish custody, that would reduce the risk of harm to those children, where maybe we could let go of jurisdiction, but dad hasn't been able to accomplish that. The little two, I visited them at their grandmother's house. Now, Mr. Rowe is in Florida, and he has been coming up to visit his daughter. He's been it's all going very well. He's doing everything that I can think of that he could do. Danny is very happy to know her dad and feels special that she might get to go live there. I don't know if the agency is thinking maybe over the Christmas holidays a transition would be made, but that leaves the littlest one with her current placement, where she is very well bonded, the child-centered home, and the older children are visiting the younger children from time to time, and they all miss their mother, but they know that she has work to do and that she's not going to be available to them for the time being, and other folks are meeting their needs at this time. Thank you.
This is one of those rare moments where the court hears some genuinely positive news. The children appear stable, they're thriving in school, and their needs are being met. But don't get too comfortable. Family court cases can change direction fast, especially when questions about custody, paternity, and parental fitness are still unresolved.
Testimony today, Ms. Thomas.
Thank you, Your Honor. If Ms. Madrid can be sworn.
So, come on up for a witness stand.
You swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Thank you. Ms. Madrid, approximately 3 weeks ago, you provided a court report and had some attachments on that court report. And from your cover page, looks like they were just the case service plans. Is that correct? Are there any, since the last hearing, we were also waiting to hear back from ICPC. And I think May results, if I'm not mistaken, or if my notes are correct. Do we have any of those documents yet?
No, the last update that I received on 10/26 from ICPC was that it was emailed to Florida on September 1st, and that Florida has still not yet confirmed that they have received the request. And that ICPC informed me that it's not uncommon for Florida to take this long.
Sorry, just trying to update my notes on that point to make sure we can address it at our next hearing. All right, thank you. And then as it relates to DNA.
Yes, so the child was tested on September 22nd, and dad was tested on September 5th. I did ask for an update after a court hearing on 10/24, and the results were still not in. DHS is helping me with that and trying to get the results. As of most recently this morning, I still had nothing.
Okay, thank you so much for that update. At this time, so it's a little bifurcated. We have one dad under jurisdiction and one dad not. So as it relates to the two younger children, with Mr. Rowe is their legal father, correct?
Yes.
Okay. And what is the risk of harm to them being returned to his care and custody today?
The only thing I'm waiting on is the ICPC request. I would say currently he is compliant with the case service plan and there is not a risk of harm.
Did you catch that? The caseworker just testified there's currently no risk of harm with the father. In child welfare cases, that's a huge statement. Once the court hears no risk of harm, the conversation often shifts from protection to reunification. The big question now is, what's actually preventing the children from going home?
And at this time, what is the risk of harm to the children being returned to mom?
Exposure to parental substance abuse, homelessness, and improper supervision.
And are those the same conditions that cause the children to come into care, to the best of your knowledge?
Yes, sir.
Thank you. What services has the agency offered, or what reasonable efforts have been made during this review period to assist the family in reunification?
Yes, I have provided Ms. Rowe with forensic fluids, drug screen availability, McCullis Vargas and Associates referral, Catholic Charities referral, LBC drug screen referral, housing help, Lenaway referral, Catholic Charities referral for Ms. Rowe, transportation assistance, bus tokens, medical and dental care for all of the children, supervised parenting time prior to her being incarcerated, relative placement, transportation for the children, and non-respondent parental home assistance.
Thank you for that. And as it relates to, so the last review period would be from July 24th, it looks like, until today. How would you describe the parents' compliance with and benefit from the case service plan?
For Ms. Rowe, she has not been compliant with her case service plan. And then for Mr. Rowe, he has been compliant in all parts of his case service plan.
Ms. Heiss, in her report, she indicated that Mr. Rowe is coming to visit the children, or one of them, it seems like. Can you just give us a little more information on that? Like how, if you are aware of the frequency or the duration or anything like that, or if there's any concerns?
Yes, he's visited on a monthly basis since our last hearing. We moved to unsupervised visits. There haven't been any concerns. He does take both of the girls, not just D. And they have, shared time in the community. They have gone to the orchard. They do a lot of normacy activities. They have spent time with his family. And again, no concerns of the relative caregiver or anyone else.
Okay. Do you believe that the children, both sets, are in the least restrictive environment to ensure their safety at this time?
Yes.
Do you have any concerns about the older children being with their father?
Besides the inconsistent communication that I've had, no.
All of their needs are being met?
Yes.
Is there anything that you'd like to bring to the court's attention today?
Not at this time, no.
Thank you. Your Honor, I have no further questions and move to admit the court report with the attached case service plans. Thank you.
No objection.
No objection.
No objection.
No objection.
Thank you. It is received. Questions, Mr. McFarland?
What's my client's earliest release date from jail, if you know?
I actually don't know. The last time we were here, she was given a PR bond and then she went back to jail in 10/27. I know that she violated her bond conditions, so that was the last update that I got in from her probation officer.
Are there any services from her case service plan that can be offered for her while she's incarcerated?
I can definitely look into the services that they provide for her. I'm not familiar off the top of my head.
Am I correct in that our jail does not allow child visitation?
That is correct.
When Ms. Rose released, should she immediately meet with you if she wishes to progress on her case service plan?
Yes.
And at that point, you'll point her in the direction of what's most relevant, what's most urgent to complete. Would I be correct?
Yes.
Would her visitations resume?
Depending on the court's decision today.
Are you asking that she not have visitations from here on out?
We did ask for suspended visitation. Depending.
And is that because she's incarcerated?
That is mainly because of that and because of her lack of participation in her services and drug screens.
Thank you. Nothing further.
Ms. Berger?
Thank you, Your Honor. Ms. Madrid, is there any reason we can't order or ask the court to order FRP services for my client?
There's no reason we can't.
Do you know if that is able to be offered to him because he's so far away?
I am not familiar with that, but I can look into it and see if they'll be willing to provide that in Florida.
Okay. Is there a specific policy requiring approval of the ICPC study before we can ask for unification?
I also am not familiar if there needs to be approval. That is just my understanding from our last ICPC request.
Okay. Okay. And at this point, you have no reason to, I guess, suspect that there would be any risk of harm for the children if they were reunified with my client?
No.
Thank you. No further questions.
Ms. Handel? Any questions? All right, the record should reflect we have been joined by Mr. Darnell Edwards.
Sorry.
Ms. Hannigan, did you need to talk with him?
It's probably briefly, Your Honor.
All right, feel free to step into the hallway. Do that. Ms. Heiss, did you have any questions for this witness?
Yes, I do. Now would be the time.
Yes.
Thank you. Ms. Madrid, if there is no risk of harm, then the children can be, I'm sorry, Danny would be cleared to move to Florida today?
Depending on the ICPC request, I'm not familiar with if we need approval or not. If we don't need approval, then yes.
You think Danny's ready to move today?
I think so, yes.
Is this father also asking for placement of Serenity?
He has indicated to me that he would be willing to also take placement of Serenity.
And are you moving her today too?
No,
Just
we do
Danny
not have the DNA results yet.
for Serenity?
Correct, for the smallest child, yeah.
So you don't think a transition plan would be needed for Danny?
Yeah, we would transition her slowly if, depending on like what the court orders today, wouldn't happen like immediate. We would definitely transition her slowly, but she would be transitioned by the time we came back to court.
Why would there be a transition if there's no risk?
Because she hasn't been to Florida in quite some time.
So that's a risk of harm. There either is a risk and she's in foster care that gets paid to keep her, or there is no risk and there's no payment to foster care and she goes home.
Well, he has completed his case service plan, and I'm just waiting on the ICPC request.
And here comes the courtroom tension. The guardian is essentially asking, if there's truly no risk, why are we still waiting? It's a classic legal dilemma, balancing procedure against common sense. Should the court wait for paperwork? Or should the child's relationship with the parent take priority? Let me know what you think in the comments.
So the risk of harm, there is a risk of harm that the ICPC comes back inappropriate, correct?
Correct.
And also that Danny just hasn't been prepared to go yet, right?
Yes, we haven't sent her down to Florida.
Have you prepared her with a counselor?
She does not have a counselor, but I have spoken to her on numerous occasions. She talks with her relative caregiver as well, and Mr. Rowe.
Okay. Thank you. I have nothing further at this time.
Redirect, Ms. Thomas?
No, Your Honor. Thank you.
Ms. Madrid, assuming Mr. Rowe is appropriate, and if he is willing to take both of the children that are both considered legally his right now, do we need to continue with the DNA investigation? Do you know what his position is?
It was ordered by the court to do the DNA test, so that's what I did. But I don't believe we would need it because he is legal father.
Well, what I'm asking is, do you know for sure whether or not he is willing to take both children?
He has indicated to me yes.
Thank you. Questions based on my questions?
Yes.
No.
All right, Ms. Heiss.
Has Serenity been prepared to move placements?
The conversation with her is a little bit more difficult, but she does know who Mr. Rowe is, calls him dad. But again, she just turned 2. So.
Right. You said that you're not planning to move Serenity, though, are you?
Until we get the DNA test that was ordered by the court, we haven't made any moves like that, no.
Okay. I'm not sure we're talking about. That concludes my questions.
Did you have any additional questions, Ms. Hennigan?
No.
No.
I'm assuming you don't.
I don't, Your Honor. Thank you.
Thank you for your testimony. You may return to your seat. Anyone else you'd like us to hear from, Ms. Thomas?
No, Your Honor.
Witnesses today, Mr. McFarland.
I would like to call Ms. Rowe, Your Honor.
Good. Have the answer. Swear in Ms. Alexia Rowe. Swearing us in the jail. You'll have to unmute and rent.
Did you unmute, Ms. Burrow?
What was that?
I just asked if you unmuted and you have. Can you raise your right hand, please? Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you. You can put your hand down, Alexia. Do you know when you might be released from jail? What's the status of your case?
I went to court yesterday and they said I can be released immediately to a rehab.
Okay,
And here I can't do nothing about it, so I'm just waiting for them to release me to a rehab.
okay. Do you wish to go to a rehab?
Yes, I do.
Okay, and if that rehab affords you parenting time, would you like to have parenting time?
Yes, please. I already missed 3 visits from being in here.
If you're in rehab, will you do the other components of the case service plan also?
Yes,
Okay. If visits can only be by Zoom, would you still do visits if they were only by Zoom?
anything to see my babies.
Okay. As far as the 2 children going with Mr. Rowe, what's your position on that?
I mean, I've always believed for kids to have their mother and their father. So I'm not denying it, but it's so far away. If something was to happen to my babies, there's nothing I could do. Nothing, I couldn't be there, nothing.
Is there anything else you need to say today?
And I also been dropping clean for my visits and everything. I came in here on a violation of probation.
What was the violation?
Because I got out on bond and they hit me with the retail fraud from when I got arrested, and they're looking into it because I didn't steal anything. So
Okay, thank you. I have no further questions. We'll see if anybody else has questions for you, okay?
thank you.
You're welcome.
Ms. Thomas,
I have no questions, Your Honor.
Ms. Berger,
No, Your Honor, thank you.
Ms. Hennigan,
No, Your Honor, thank you.
Ms. Heiss.
Just one. Ms. Rowe, did you get to your psychological evaluation on October 30th? You probably didn't.
No, I went and then the lady at the desk said that it was an Adrian, and I contacted Francisca about it, and she made me a new appointment, but being incarcerated. But I mean, as soon as I'm released, I'm willing to go. I've been wanting to get it done.
Okay, thank you. Nothing further.
Okay, Ms. Rowe, it's unclear to me here's what I have. You were incarcerated as of June 21st, 2023 as a result of a violation which consisted of positive drug tests. And then you were released at some point, is that right?
Yep, I was released, and then not even a week later, I went to report and they arrested me on a warrant for retail fraud
When were you released?
on a Thursday.
Do you know if it was July, August? How many days were you out before you went back to jail?
It was October. And I was out not even a day away from a week. I went and reported on a Wednesday and they arrested me when I went and reported. My probation officer didn't even want to arrest me, but it was too late to see a judge.
Okay, thank you. I just wanted to make sure I understood what was happening. When is your next court date?
The 30th, but I am to be released immediately to a rehab if they can get me into one.
Thank you. Okay, any questions based on my questions, counselors?
No.
Yes, Your Honor.
Yes, Your Honor.
All right,
I have
let's
one.
Ms. Thomas first.
Well, a couple. Ms. Rowe, so your testimony, you were released probably October 27th.
I think so, yeah.
And did you take any drug screens after you were released from jail?
Yes, I did. I took one.
And isn't it true it was positive for meth and cocaine?
Yes, but my probation officer was looking into it because I'm clean for, when I test for my visits, and then that one wasn't dirty. So we asked for it to be sent in.
When was the last time you tested for visits?
My last visit I had, I forgot what day it was on.
Was it a week ago? Was it 2 weeks ago? 3 months ago?
Like 2 weeks ago, not even.
Okay. Thank you. Okay. Thank you, Your Honor. I have no further questions.
Ms. Hennigan.
I had the same questions, Your Honor.
Okay, all right. Thank you for your testimony. Anyone else you'd like us to hear from?
No, thank you.
Ms. Berger?
No, Your Honor.
All right. Ms. Hennigan? Any witnesses today?
Not for this portion, Your Honor.
Very good. Do we know what's happening with your client?
Yes, I sent him upstairs to get a notice of hearing for proofs for you. I sent him to the third floor clerk's office.
All right. Okay. Well, for purposes of the review then, comments, Ms. Thomas?
Your Honor, I'm actually at a loss of words right now about, I guess, a few things.
Notice how the focus is shifting away from allegations and toward accountability. One parent has completed services and stayed involved, while the other is still battling incarceration and compliance issues. Family court judges pay very close attention to patterns, not promises. Consistent action usually speaks louder than good intentions.
I understand Ms. Heist's position that, the risk of harm to the two littles about going with Mr. Rowe at this time is sort of that psychological harm and being prepared mentally to go. But the testimony today has demonstrated that Mr. Rowe is in compliance with his case service plan. And I'm not sure if there's no longer a risk of harm from that regard, if it's appropriate for us to continue asking for jurisdiction over him. But I think that we run into the same problem as the older children, that we don't have custody orders in this case, that releasing these fathers entirely from the cases sort of defer to our case as a custody order. And I'm not sure if that offers the most stability and permanency for these children. So with that, I will leave it to the court's discretion to order what we need, I guess. But I know that the intention of the last adjournment was to allow for Mr. Edwards to file that custody documentation. Given that he said he filed it, it seems that there's likely a notice of hearing. I'm going to request that maybe we again revisit that idea of a show cause, but I'm not going to move for that at this time. Thank you.
Comments, Mr. McFarland?
Well, Your Honor, my client is going to be entering into a inpatient rehab program. I would ask that the court not suspend her parenting time, that whatever that program allows, as long as she's in compliance with the program, to have visits with her children, since there's not a request to terminate her parental rights at this hearing. And you've heard her opinion regarding the children going forward. Thank you.
Ms. Berger?
Yes, Judge. After we began our closing arguments, my client did message me that he would like to add something to that Duke's testimony from last week. So if we could entertain that, I'd really appreciate it.
I think that's appropriate. Mr. Rowe, can you hear us? Mr. Trayvon Rowe, can you hear us? Are you still with us? See you logged in.
Hello?
Yes, Mr. Trayvon Rowe, can you?
Yes, ma'am.
Is this true? Okay. Deputy Ames, would you please swear in Mr. Trayvon Rowe?
Mr. Rowe, can you raise your right hand, please, sir, and let me know when it's raised?
Thank you.
Thank you. Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Trevon, can you hear me okay?
Yes, ma'am.
Did you hear the testimony of the caseworker and of Miss Rowe today?
Yes, ma'am.
What would you like to add?
I would just like to add for the ICPC, I did some research on my own. I got a hold of the ladies, some of the workers down here that did the ICPC. And the reason that it's being held up is because I've had a court going on for almost 2 years. And my court date for down here is December 8th. And once they come up with the cost that I have to pay, then it'll be done. But they won't clarify, the ICPC won't deny it as long as, how do I put it? They won't grant me it unless the court is over with. So that's why the ICPC got denied the first time, is because I have a court going on. And so, and it'll be finalized in December. And December 8th is my court date. as when I get the restitution of how much I owe, and then it'll be done. But that's what the holdup is down here for my court. That's why they keep on pushing it. But I haven't contacted the lady's number for who does the ICPCs, and so I told her that before she pushes it through to deny it or whatever, if she could just wait until the court date was done, because otherwise they just keep denying it until the ICP court date was complete.
Okay, so is it your understanding that they want to approve it, so they're holding it until that criminal matter is resolved?
Yes, yeah, that's why it's taking so long. But I don't know if she hasn't received it yet though. But I told her when she does that's what she told me. She said that once it goes through, if your court is still going on, then they'll deny it. So I asked her, and she was looking into it if they could just wait a couple weeks until the court finalizes it down here, and then it won't be denied. But it'll keep getting denied as long as I have a court date down here.
Right. Who hasn't received what?
They haven't. I guess so. I talked to the lady. They sent it, but they didn't get an email or anything. They were up. You guys up there were supposed to.
Time out. Who is that?
The caseworker up there.
So the Michigan caseworker has not sent something to the Florida caseworker?
Yeah, because I talked to her and she said that she hasn't even received it. It hasn't come down here or nothing. And she said to check the emails, to check the caseworker's emails to see.
So the Florida worker hasn't received the ICPC request from the Michigan worker?
No, not this time. They got the first one, but not the second one.
Okay. And have you filed anything to get private custody of your children?
I wasn't aware I could do that, but I can start getting on that as soon as possible.
Have you filed any documents in any other court?
No.
Okay. Have you filed for divorce?
Yep, that's done, but if she doesn't respond within the 20 days, which has been 22 days, so now I have to file another paper since she didn't respond.
Okay, and you have your children listed in that divorce, correct?
Yes.
Okay. Okay, I have no further questions. Do you have anything else you want to add?
No, ma'am.
Okay, thank you.
Yep.
Ms. Thomas,
I have no questions. Thank you, Your Honor.
Mr. McFarland,
Sir, when did you file for your complaint for divorce?
I filed my divorce, it had been the 1st of October. I served her on the 17th. She got served on the 17th of October.
For example, in Michigan, if you have minor children, it's usually 6 months. How long does it take in Florida to go through with
90 days.
90 days, okay.
Yes, ma'am. Yes, sir.
Okay, so you're filing for default against her is what it sounds like, and you're asking for
Yes.
physical and legal custody of the 2 children?
Yes.
Okay, just so I know. And refresh my memory, what was the conviction that you have to pay restitution on?
It was criminal mischief.
What does that mean? What did you do?
I broke something, and so now I have to wait for them to get the price of it.
Well, what did you break and where?
It was a glass, piece of like a window.
Was this a domestic situation or what?
No, I was intoxicated drinking, and I've already completed the classes for that for my probation down here. I've actually completed probation. It'll be done on November 12th.
Okay, do you have alcohol in your house right now, like beer?
No, sir. I report every week.
The relevance is he's convicted with the ICPC. We want to see how fit he is, and if he was involved in a crime with alcohol. I want to make sure the kids are going to be returned, but they're not going to be returned to a lifestyle with alcohol. But that's why I believe the relevance is right.
it is relevant, I think, so I will overrule the objection for those reasons.
And I think he has a favorable answer anyway. So, your answer, sir?
Can you repeat that?
Sure. Do you have any alcohol in your house?
No, I report every week, and I don't have no alcohol. I don't drink. I've been drinking over a year and a half.
Good. And
I do drug screens every week.
okay. Is that a felony or a misdemeanor that you're on?
Misdemeanor.
And how much longer do you have to pay your probation off?
I'm prepared to pay it whenever. As soon as December's 8th comes, it's all getting paid.
Your probation was for how many months or how many years?
It was for 12 months.
And it began when, just to see?
Sometime November last year.
Oh, okay.
November 12th is when it started.
Gotcha. Nothing further, Your Honor.
Any questions of this witness, Ms.?
Yeah, thank you, Your Honor.
Mr. Rowe, you've been seeing Danny and you've been coming to Michigan to see the girls, right?
Yes, ma'am.
And have you participated in a DNA test for Serenity?
Yes, ma'am.
And you are the legal father because you're married to Serenity's mom, but are you wondering whether you're the biological father?
I did a home DNA test, so I know I'm not.
Okay.
But
So
I'm aware.
So if there, would you engage in some planning with this whole team, this whole case about whether Serenity goes with you or stays where she's at after the DNA test?
Yes, ma'am.
Yeah. And then, do you think Danny's ready to come to you immediately?
She cries every time I drop her off. She doesn't want me to go.
Yeah, you guys are getting a very good relationship. She wants to go to you, right?
Yes.
Okay, that's all. Thank you.
And every time I call her, last time I was up there, she thought that I was coming to bring her back with us. And Debbie had to tell her it wasn't time.
Yeah, she's looking forward to Disneyland in Florida, I think, right?
Yeah. Yeah.
Okay, thank you. Nothing further.
Okay, thank you for your testimony.
I do have one question, Your Honor, based upon Ms. Berger's question.
I was going to ask her a follow-up question. That's true. She didn't.
What is it?
What's your question, Mr. McFarland?
Sir, well, your attorney asked you a question about Serenity. If she is not your biological child, do you still wish for her to come down as your legal father? I guess I'm confused about that.
What I was saying, if there's an option for her to come down here to be with her sister, so at least there's Danny and Serenity together, then that'd be fine by me. Like, I don't have a problem. She's getting to know me. I spend time with her. I buy her stuff. I take her out when I go up there. So I don't have a problem with it at all. It's up to whatever you guys really want to do.
Well, my question to you is, if she's not your biological child, do you still wish to remain in her life as her legal father and for her to be your legal child? That's my question.
Absolutely.
And there it is, the emotional twist nobody expected. Even after learning he isn't the biological father, Mr. Rose says he still wants to remain this little girl's legal father. That's a powerful reminder that parenthood isn't always defined by DNA. Sometimes it's defined by who shows up, stays involved, and chooses responsibility. Do you think the court should consider biology or commitment more important in a case like this?
Thank you. Nothing further.
Okay, thank you. Anyone have any other questions?
No.
Very good. Well, thank you, Mr. Rowe. That's very helpful to us to know your position.
Yep.
All right.
Yes,
Comments?
thank you very much. I would ask that my client be terminated and an order for unification be entered today. There's no risk of harm that is associated with his home or his house. I don't think that we absolutely have to have an approved ICPC. He's been open and honest with us this entire time. He's been compliant with his probation officer, who has sent very, very good reviews to the caseworker. He's completed his case plan service. He's gotten his home ready for his children. He's made the trip up here, driving several times to visit with them for extended periods of time. He does virtual visits. And he's getting specific permission from his probation officer to even leave the state to come and see them. So he's very committed. He's been very consistent. If there's no risk of harm, I don't see how we can continue to hold jurisdiction over him. He has filed for divorce in his current state, and hopefully that can come through as well. So at this point, I would ask for reunification to happen and that we begin that transition period as soon as possible. That way, maybe when there is a break or a larger time off of work or school or other activities, they can complete that transition period without disrupting too much of our everyday life.
Ms. Hennigan, comments, updates for you on your client?
Yes, Your Honor. In the interest of time, I have been able to gather some information with regard to my client's situation I'd like to share with the court. And then I would be hopeful that the court would give Mr. Edwards some direction on this matter and perhaps not full show cause on him. Mr. Edwards did file paperwork with the front of the court. However, it apparently needed to be filed with the circuit court. It was set for hearing for December 26th in front of the court as an intake, and there was a misunderstanding there. So when he went down to speak with them, he came back to me and gave me an extension to call. I did speak with them. They verified that information. So they're canceling the hearing that is scheduled for December 26th and have directed that he will need assistance doing two things, for which I am hopeful that this court will direct him to seek out services from possibly Southeast Legal Services or something like that. One, for Jayla, there is or has been a case opened on her previously, and so either $100 fee or a fee waiver for indigency could be submitted and file a referee petition for change of custody, and then FOC will get a new hearing set for him with regard to Jayla. Two, with regard to Jordan, there is no open case, never has been an open case, and therefore he will have to file a paternity action and establish custody simultaneously, and can use the paperwork that previously helped him to complete to take that action with the circuit court. But it's clear to me through our conversation today that I may not be able to assist him in that manner from my capacity in this case, and that he likely does need to seek some legal counsel to help him with that so that he can get it completed in a timely manner.
Ms. Heiss, I look forward to your thoughts.
Thank you, Your Honor. Mr. Edwards has got an uphill battle because, there was a case with Jordan and that other fellow was paying child support and he's the legal dad. And I do know it will get cleared up, but it is not an easy case. And Mr. Edwards is meeting the children's needs. That's we do need to know that their needs are being met, so that if we take the time that is needed to get this thing right, I think that would be appropriate. So those two children are in school here. They're doing well. With respect to the younger two, I really think we're not communicating well here today. I think that Mr. Rowe is intending to, if Serenity needs a home, but if we were to have a family meeting there, Serenity may be bonded and maybe better placed somewhere else if the DNA comes up differently. I don't think anyway. Mother's visits were sporadic and she missed visits and she wasn't screening and she's in jail. I would ask you to consider suspending those visits until she's released, so that we can, or at least when she gets into treatment, we can do a family team meeting, ask what the visit guidelines are, and petition the court to have that visit be supervised. Thank you.
Your Honor, if I could add just a small bit just upon Mr. Rowe's testimony, since it was after my closing.
Go ahead.
Thank you. The only uncertainty and the risk of harm I see with Mr. Rowe is that he's had almost a year to pay restitution. He hasn't done that. And if it's not done, as he indicates it would be, he could be violated on probation.
Judge, I'm going to object. That's not what the testimony said. He has agreed to pay restitution and is paying it on the 8th. He doesn't have the number to pay. How can he pay it if he doesn't know how much it is?
That was my understanding as well, Mr. McFarland, but they haven't told him what the restitution is.
There's still a possibility that it may be more than he can afford, and probation can continue. And if it does, it could be violated. I know his behavior doesn't indicate that, That's a risk. Plus, he still does not have a custody order until December, so I think that'd be the more appropriate time to look at finality. So that's our position on just that. Thanks.
Anyone else have any additional comments? Well, the court finds that all interested parties were given notice for purposes of today's review hearing. The children have been out of the care of their mother, who had primary rights to them, as far as I understand, as of October 7th, 2022. She's been consistently, frankly, disengaged with services and unable to overcome the barriers for reunification. And I've heard that consistently from Ms. Madrid, including up through today, as far as the risk of harm associated with returning the children to her care. She has a long road ahead of her to establish sobriety, overcome her criminal charges, and educate herself and demonstrate that sobriety is a consistent pattern and be a healthy parent for her children. I do not find that there's any reasonable time frame, given the ages of these children, for that to be accomplished, and I would ask the department to consider filing a termination petition. I'm not going to order that, but I think that it could potentially answer some questions as to who would have rights to these children. I look forward to Mr. Rowe. If in the meantime, between now and when we come back, Mr. Rowe, if you end up with an order from Florida that gives you custody of these two children, please forward it as soon as possible to Ms. Madrid, and we will entertain that as a way to ensure that these two children are returned to you. I also don't see, I see your success, and I look forward to that. I would need to confirm, I think, Ms. Madrid, that the only reason that the initial ICPC was denied was on the basis of those outstanding criminal charges. So as you move into our next review period, I would say that if, in fact, that was the only reason that the ICPC was initially denied, that you should be returning this child to the care of her father. And frankly, both of the children to the care of this particular parent, who is still, for all intents and purposes here, their legal father. And if he's willing to take them and that allows them to be together, that would be appropriate. But I will ask you, before you make that decision, to have that family team meeting, as indicated by Ms. Heiss, that could be useful in order to answer both my concerns and the concerns that she raised in her comments. But if DR is ready to go and everyone is satisfied that that's in her best interest and she's ready for that, then I would look forward to that notice that she has been reunified with Dad. As it relates to the other two children, yes, it's a very complicated road ahead of Mr. Darnell Edwards. That's very clear. It's also come to our attention, Mr. Edwards, that as a result of rather recent changes and specific decisions that have been made by the Public Defender's Office, that Ms. Hennigan is no longer available to you and must be released from our court, because otherwise she would be operating for free, and I'm not going to require her to do that. So as a result of the delay, frankly, one of the additional consequences is that you no longer have access to Ms. Hennigan for purposes of assisting you. That leaves it to you to move in front of the court as articulated by Ms. Hennigan. So in other words, you do need to still ask front of the court for to revisit the custody arrangement on one of your children that you already have an arrangement on with Ms. Rowe, and then on the other child to file in circuit court. So I wish you the best of luck. Again, this is where, in part, Ms. Thomas, I would ask you to consider a termination petition as it relates to Ms. Alexia Rowe, so that in the event that she is released, that there would be no question as to whether or not she has any rights to these children under those custody agreements or arrangements. I don't think I can release either, well, especially the third child, JT, because she is still concerned under another case and would have the risk of being awarded to the care and custody of the previously determined legal father, Malcolm Tyndall, frankly, who obviously would not be interested in that. But you, other than the temporary orders that have been established by our court, Mr. Edwards, you have no legal right to that child. So by de facto, she will probably end up staying with you, especially if they move to terminate Ms. Alexia Rose's parental rights. But as it relates to your ability to take her to the doctor, enroll her in school, or otherwise care for her as a legal parent, once this court's jurisdiction is terminated, so are your rights to do that. That may put us in a position where we have to look at adoption as currency for this child or some other method. It's an insanely legally complicated situation that we have, and it's frustrating that we haven't had any movement on your end to try to help resolve this, which does speak, frankly, to your parenting skills. All right. The children are going to remain placed where they are under the jurisdiction of the court. Under the remarks that I've made, the two of them will remain placed with Mr. Edwards. We'll look forward to potentially reuniting Mr. Rowe with the other two children in the next report period, and what, if any, actions may be necessary with regard to Ms. Alexia Rowe, and look at the case again in January for our next review. Yes.
Will your order specify that the department has the authority to reunify?
So what has to happen is if they're going to, I mean, I can put that in there, but I still need them to operate under the court rule that indicates that if they're returning a child to a parent, then they have to provide notice to all attorneys, and then the attorneys have 7 days to object to that. So for example, I wouldn't want Ms. Heiss left hanging, frankly, without an answer as to whether or not, for example, the older child, SR, is placed with in Florida. If she's sent to Florida and she doesn't agree with that, then she needs 7 days in order to make those objections known, right?
Perfect.
It's an insulation for both our caseworker and the department, as well as for the other parties, and especially for our LGAL, to have that notice ahead of that reunification, so that if there are any issues, that those can be heard before that.
I didn't pick up if my client's parenting time is suspended or not.
I haven't made a ruling on that.
Okay.
She, by practical effect, has no parenting time as a result of her incarceration. If there is parenting time available to her at a rehabilitation facility, I will ask for a family team meeting to take place to determine whether or not, when, and how that's appropriate, and to inquire of a professional on that point, frankly. And of course, if there is a termination petition filed, that would be a situation where we'd have an automatic suspension of parenting.
Your Honor, if I may, I just want to indicate that back in April or May, the ICPC denial for Mr. Rowe was submitted to this court, and it does indicate that it was based on the preliminary search of his criminal record at that time. But I want to also note that because the children are under the care and custody of the department, we are unable to move across state lines without the ICPC approval. So if we release the children from jurisdiction under a court custody case, that's different. But because they're under the department's care and custody, we cannot do that unless, I guess, it would be a directed placement, or we're not involved in this case.
My understanding is that a child may be placed with a parent out of state. I've seen it done in other cases, and if, even in a situation where it was simply a putative father, not even a legal father, and that was Ohio, not Michigan. But maybe we need to review what the agency can and cannot do, because either that situation was incorrect or this one is. And I would like to know, frankly.
And I also don't know if it matters based on whether if the parent is a respondent or not. And I don't know, again, I'm not well versed in that, to know that. But I just know that until something else.
Well, I guess what I will ask then, and Ms. Madrid, this will be up to you. If it is your opinion, and Ms. Heiss concurs with your opinion, that it is in the best interest of both of these girls to go to Mr. Rowe in Florida, just bring me a petition, a motion, something that will allow you to legally make that happen. And if you're concerned about needing permission to do it, you know where to find me. Hopefully that helps. Any other questions? None?
None.
Okay, so I've scheduled our next review for Friday, February 2nd at 9 a.m. and I'm hoping you're all available.
Yes.
Okay.
9 a.m.
9 a.m. We have a 10 o'clock in another courtroom for a conflict case, but 9 a.m. is free. Thank you for letting me know that. Is that up in circuit court? Yes, Benton just got set today. Okay, all right, thank you for letting me know. I'll make sure we don't double book that. And it will be a privacy planning hearing in addition to a review. And unless there's any other questions, that's all for today.
Thank you.
Thank you, Judge.
Thank you. Good luck.